Talbot Smith recorded one phone call with his supervisor. The recording lasted maybe 5 minutes. He saved it to his phone, thinking he was simply documenting a conversation that might matter later. It cost him a felony charge and 4 years of legal battles. He didn't know that in Pennsylvania, where he was sitting in his office at Unilife, that recording had already become a crime. In 2014, Talbot worked at Unilife, a medical device company in York County, Pennsylvania. His supervisor, Ramin, called him to discuss a change in his role. Talbot had felt uncertain about his position for weeks. The call was unexpected, and his gut told him something important was coming. He felt he needed a record of what Ramin was about to say, something he could refer back to, something he could prove if there was a dispute later. He reached for his iPhone, opened the voice memo app, and pressed record. No announcement. No mention to Ramin that the app was capturing every word. Talbot thought he was just documenting a conversation. He assumed his phone was just a phone, that recording a call he was part of was ordinary and legal. People use their phones to save voicemails all the time. He did not know that Pennsylvania had a rule most people had never heard of, a rule that made his recording a felony, a rule that would define the next 4 years of his life. The promise of this episode is simple. You probably don't know whether it's legal to record a conversation in your country, your state, or the next city you visit. And that ignorance can cost you years. Here's what Talbot didn't know. Pennsylvania is not like most places. In Pennsylvania, everyone in a conversation must consent to being recorded. This is called all-party consent. Under the Pennsylvania Wiretap and Electronic Surveillance Control Act, recording another person without their knowledge is a criminal offense carrying up to 7 years in prison and a $15,000 fine. The law makes no exceptions for documentation, self-defense, or innocent intent. The act of recording itself is the crime. One iPhone recording had turned Talbot into a felon. But here's where it gets interesting. The same recording would have been legal in 38 U.S. states and Washington, D.C. In 38 states, you can record a call you're part of with no permission needed. This is called one-party consent. If you're in the call, you can record it. No notification required. No permission slip needed. Just record. The contrast sharpens globally. In the United Kingdom, the Investigatory Powers Act 2016, Section 44, explicitly permits you to record your own conversations without telling anyone. One-party consent is not just legal, it's codified. You are a party to your own words. You can capture them. In Germany, the opposite is true. Section 201 of the German Criminal Code makes it illegal to record someone's words without permission. Violators face up to 3 years in prison. The same conversation, same phone, same innocent intent. Legal in London, legal in Ohio, illegal in Munich. Talbot didn't know he was on the wrong side of an invisible line. And that line, invisible and arbitrary as it was, had just turned his life into a criminal case. When Ramin found out the recording existed, he reported it. Talbot was charged with a third-degree felony. The case went to trial in the trial court, where the judge dismissed the felony charge, reasoning that a smartphone recording app wasn't an interception device in the way the 1968 wiretap law intended. A smartphone was not a wiretap. An app was not surveillance equipment. But Pennsylvania appealed. The state argued that a smartphone app was exactly like a tape recorder. It captured audio, and therefore violated the law. The Pennsylvania Superior Court agreed. The judge's dismissal was reversed. The felony charge was reinstated. Talbot's case was remanded for further proceedings, meaning the criminal prosecution resumed and the battle continued. Talbot had lost his first battle. The legal bills, the time, the stress, all real costs that he had to keep paying. Here's the mechanism that protects you if you know it exists. In the United Kingdom, the Investigatory Powers Act 2016, Section 44, gives you a specific legal right. You can record your own conversations without telling anyone. You do not need permission. You do not need to announce the recording. If you're a party to the call, you can record it. This is called one-party consent, and it's the legal default across most countries and most of the United States. But the United States operates on a dual system. Federal law, 18 U.S.C. Section 2511, permits one-party consent nationwide as the baseline. In 38 states and Washington, D.C., you can record if you're in the call. Period. No notification needed. No consent slip needed. 13 states have rejected this federal baseline. Those states have passed their own criminal statutes requiring all-party consent. Pennsylvania is one of them. California, Florida, and Maryland are among the others. If you're in one of these states, everyone in the conversation must consent to being recorded before you press record. If you have already made an illegal recording, the remedy has multiple parts. First, do not share the recording, introduce it as evidence, or broadcast it. The act of distribution compounds the criminal violation. Second, delete it if possible. Third, and most importantly, immediately contact a lawyer. In Pennsylvania, where Talbot recorded, the violation is criminal law, not civil. A lawyer can mount a defense, identify exemptions, or negotiate a settlement. Do not try to handle this yourself. The prevention is simpler than the remedy. Before recording, know which jurisdiction you are in. If it's one-party consent, record freely. If it's all-party consent, you must tell everyone on the call and get their permission. That single conversation, asking permission, is the entire difference between a legal recording and a felony. Talbot's call came in 2014. Let's run it forward differently. Ramin calls. Talbot answers. Before anything else, Talbot says, "Ramin, I'm in Pennsylvania and the law here requires everyone in a call to agree to be recorded. Is it okay if I record this conversation?" That's sentence. That's all. Ramin might say no, but at least Talbot knows the law. If Ramin said yes, Talbot records legally and has the documentation he wanted. He has proof of the conversation. He has certainty. If Ramin said no, Talbot makes notes instead, where he tells Ramin he needs to stop and reschedule the call with HR present. Either way, no felony charge, no court battles, no years of legal fees, no stress that bleeds into every part of his life. That one sentence, asking permission explicitly, was the only thing standing between Talbot and his outcome. It wasn't complex. It wasn't expensive. It was a single conversation that changed everything. The mistake wasn't that he recorded. The mistake was that he didn't know the jurisdiction where he was recording. He assumed his own knowledge was enough. It wasn't. He assumed the law where he lived was the law everywhere. It isn't. This trap is global. In Australia, recording without all-party consent is illegal. In Canada, the rule depends on the province. Some allow one-party consent. Others require all-party consent. In Germany, Section 201 of the Criminal Code carries up to 3 years in prison. In India, the Information Technology Act Section 66 decriminalizes recording without consent. But the landscape is shifting. In New York in 2025, the state legislature introduced bills to change the state from one-party to all-party consent, though the bills remained in committee as of early 2026. In Oregon, courts now require that people are specifically told they're being recorded before in-person conversations can be recorded. The rules are not frozen. They're alive and they change.